honor. I think I will learn it latest when I will say goodbye to you. And it's a great pleasure and a great honor to have such a distinguished panel here with three panelists which do not need any further introduction. And I think it's a great composition that we have also different perspective. First of all, Judge Ian Forrest with the perspective of the European Court of Justice or the court. Perspective from the US with Judge Ginsburg giving us a different view on these issues, and also having someone from the European Commission who is at the forefront of these cases, who is investigating these cases and will then be reviewed by the judges and what the Commission did. We agreed, even though usually we would start with the judges, that for reasons of the order for reasons to increase, let's say, the pressure on our first speaker, that we will start with the first speaker describing the practice of the European Commission, and afterwards give the judges the opportunity to give their introductory remarks and also to react immediately what they've heard before that. So without any further ado, and having said that, it's a great pleasure for me to hand over the mic to Chris de Keyser and hearing his words.
Thank you very much, and thanks for inviting me and also for organizing this conference on such an important topic for all of us. So, disclosure of evidence, which is the topic of this first panel, and I'm trying now to, is of course crucially important for companies because it allows them to exercise their rights of defense effectively. But as it's also shown by and explained earlier this morning, this is only one element amongst many others to ensure procedure fairness in competition proceedings, and therefore, before zooming in on disclosure of evidence, I thought it may be good to take a step back and look a little bit at the bigger picture of procedure fairness, which is ensured by a number of elements taken all together. And so on the left slide, part of the slide, you see a bit the roadmap of a typical antitrust investigation, and the procedure rights that apply. And on the right side, I have put what I would call the pillars in the EU, in the European enforcement system, to ensure unbiased and impartial competition enforcement, so key elements for offering robust outcomes. And I will quickly mention them. So first we have a system anchored in the rule of law. So our powers are enshrined in a treaty, defined by law, investigation powers, for instance, which are mainly inspections and RFIs, contrary to the US, where you have much far-reaching investigation powers. They are defined by Regulation 1. Secondly, there is a continuous and high standard of procedure fairness and impartiality, and respect of the rights of the parties is being guaranteed at all stages of the proceedings. So concretely, when we exercise our powers, we do it with respect to due process throughout the proceedings. So during the investigation phase, for instance, guarantees are already built in so as to respect what I would call corollaries of rights of defense, LPP, right not to incriminate oneself, the duty to inform the parties, under investigation of the purpose, etc., etc. So once things then become really serious and formal allegations of wrongdoing are made, so the hard rights of defense kick in, right to be heard with the right to SO, right to reply, access to file, right to reasoned decision, and also important in our system, also third parties have procedure rights, such as complainants and other third parties. On top of the guarantees provided for in the legal framework, we have also put in place a comprehensive system of internal checks and balances to ensure that robust and sound outcome in cases. So the hearing officer is the guardian of procedure rights, not only from the parties, but also third parties, complainants. Then we have internal scrutiny units, the chief economist, the peer review panels, legal service advisory committee, which are all additional safeguards for a robust and substantive assessment. And then, as it was mentioned this morning, the decision is taken by a college of 28 commissioners. Fourth, our procedure and decisions, as it was mentioned, are subject to judicial review. So stringent and meticulous control on all points of fact and law, with review of evidence, factual findings derived from it, legal qualification, And for instance, if we get it wrong on disclosure of evidence, as occasionally happened in the past, such as for instance in UPS TNT, the court comes in and annuls. Finally, the Commission has also taken a range of initiatives to increase transparency, which is also important. We have a lot of best practices on antitrust proceedings, on merger proceedings, on the submission of economic evidence. We have published the inspection explanatory note. So a lot has been published, and of course we publish all our decisions, which is a very important element also in terms of accountability of our actions. Turning now to the topic of disclosure of evidence. So already during the investigation phase and in line with best practices, the Commission provides the parties with key submissions from complainants and third parties, so including a non-confidential version of the complaint, economic studies and so on. Then, but it is really with, as it was also mentioned, with the statement of objections that we set out the preliminary position of the Commission on the alleged infringement. So there we give the parties the right to be heard on the matters on which we have objected. So it's with the SO that the parties get all the information they need to exercise their rights of defense effectively, both in writing and orally, and that they can comment on the allegations made. And it's also the SO which mentioned all the documents which are then considered as admissible evidence against them. So parties can, of course, contest the SO in all any way they see fit on facts, law, economics. And so at that stage, they get access to the file. What does that mean? Access to the file is the evidence coming from inspections, RFI, submissions of complaints, leniency applicants. So in short, documentary evidence, in our system, paper documents. Parties have access to all the documents, all of them, which have been obtained, produced, and or assembled by the Commission during the investigation. So a requirement coming from the case law, which is now also provided for in our regulation. It's a precondition for the equality of arms. There are two exceptions to this rule. Internal documents do not constitute evidence on which the Commission can rely in its assessment of the case. And secondly, business secrets and other confidential information, because the disclosure of that could harm, of course, undertakings or other persons. And there, in practice, it means that during our investigation, we have to make sure that for every document which gets into our file, we get a non-confidential version with the same evidential value as the original document. So, of course, as you can imagine, preparing this is quite a daunting task. So in many cases, we have 10,000s of documents. In a recent case, we had a file with 600,000 pages. And this is not even fully capturing the nature of today's evidence. So in Google Shopping, we received and analyzed about 5 terabytes of data. So efficient access to some extent also depends on the cooperation of parties and undertakings having provided information. Sometimes we are criticized that we take very long, but part of that is linked to the fact that sometimes we need to take the time, and we have to take the time to do access to file properly. So every document registered, we need a non-confidential version. Requests should be reasoned, and again, we rely heavily on lawyers, which can make our life easier, because the more cooperative parties are in that process, the quicker it works. In the process, also the hearing officer plays an important role, because if there is a dispute between the parties subject to the proceedings, between third parties, between the Commission, and then the hearing officer decides. In principle, access to file is granted by giving the addressees of the SO access to an electronic version of all the documents in their non-confidential format. However, in certain cases, and especially in those cases with a limited number of parties, and in order to alleviate the burden on companies to redact their submission in relation to confidential versions, we have introduced 2 procedural practices. One is data room procedure, so which is primarily used for the verification of large amounts of quantitative economic data collected from third parties, such as cost, price, sales, So under this procedure, part of the file, including the confidential information, is gathered in a room, and then access is given to the room to a limited number of people, the external counsel, the economic advisors. And we can also propose to the parties to have a confidentiality ring, so a negotiated disclosure procedure. For instance, if it's very difficult to provide a non-confidential version, so in cooperation with the parties, we release it in the confidential room to a restricted number. So in principle, access to file takes place once after the notification of SO and before the oral hearing. However, there are situations where we also give access after SO. For instance, if there is potential exculpatory evidence included in the reply to the SO, access is being given. If new evidence comes into the file, we give the relevant parties access to these documents as well. Sometimes the new evidence changes the characterization of the infringement. In that case, we even prepare a supplementary statement of objections with the new access to the full file. Special rules are in place for settlement and cooperation cases, also, for instance, for access to settlement submissions and leniency statements. Probably no need to go into detail there. Our system also includes, of course, procedure guarantees, so that we get it right on access to file. During the procedure, we have the hearing officer. So so the parties can make a reasoned request to the hearing officer if they consider, for instance, that there is a document in the file which has not been disclosed for them. Parties can go to the ombudsman, and of course, as I mentioned already, it can be put at the level of the court, which can then annul the decision. Before closing, there is still probably one issue which I would like to bring up, and it relates to an issue which was also mentioned by the Advocate General. So due process for companies subject to competition proceedings cannot be disclosed in isolation. As I mentioned already, also third parties have certain procedure rights, so which means that sometimes we have to balance and reconcile different procedure rights with each other, the right of parties, rights of defense of the parties versus the confidentiality of business secrets and confidential information, for instance. But more generally, we also need to find this right balance between due process on the one hand and effectiveness and timeliness of enforcement on the other hand. Or put it differently, between accuracy and administrability. And one of today's biggest challenges when it comes to the type of conduct by dominant players, which we see in digital markets, is to keep pace with market developments and to accelerate our proceedings, while on the other hand, fully safeguarding the rights of defense of the parties to these proceedings. And this is all the more challenging with the ever-increasing volume of data and digital data in our files, and also the request to have as much information as possible and to share it with the addressees. So it's time-consuming, it's burdensome, it's resource-intensive for all actors involved. So two concluding thoughts in this respect. This is also and probably essentially a question about where to draw the line for what should be considered the requisite standard and burden of proof in some of these cases. So the bar under EU competition law was set at a conclusive showing of potential harm to competition. If that bar were to reinterpret it, as it is sometimes argued, still last week for instance, at a level which would require regulators to show actual harm and to adduce actual proof for every element related to the conduct at issue, this would in many cases not allow to intervene at a point in time where intervention can still make a difference. So it is at a stage where competitors can still exert a competitive constraint in the absence of the abusive conduct. And it's there where presumptions can provide the possibility to reconcile accuracy and administrability. So with a presumption, you allocate the burden of providing evidence at different stages of the analysis between the Commission and the party, which can also result in more effective enforcement, because it gives an incentives for companies to come up early on in the process with their best evidence in order to rebut the presumption, and thereafter the burden of proof shifts again to the Commission, But if they are convincing in that first phase, it can happen that the Commission even closes the case. So it's in the interest, I think, of all involved. Second and final thought, with the ever-increasing amounts of documents and data in our files, the reconciling due process on the one hand with timeliness may also call for more vigilance of enforcers and regulators to keep better under control potential abuse of due process possibilities or attempts to delay or derail proceedings. And with this, I have come to the end of my initial remarks, looking forward to the interesting panel discussion later on. And so I hope that I have convinced you that we maintain the highest standards in our system, so swift and efficient procedures, thorough and accurate decisions, and procedure fairness. Thank you very much.
Thank you very much. So after this last word, we don't need any further presentations because everything is okay and the due process works as it should. I still would like to hear the view of the judges and what they think about it. And I suggest that we take questions after all three presentations, and therefore I would like to continue with Judge Forrester's thoughts.
All right. Well, I am a former practitioner, an occasional writer and teacher, and currently a judge. And I have been in that happy position for the shortest time. And so you'll need to decide whether I have shed my spots as a practitioner completely or not. Not sure, we can decide later. I begin with a practitioner's experience and anecdote. We're talking about access to the file, and we're talking about due process. I appeared as a practitioner in an Eastern European jurisdiction in a competition case on behalf of a client who was accused of abusing its dominant position. And a fine, which was in local currency terms impressive, had been provisionally imposed, and the company now had its opportunity to be heard by the Competition Authority. And I requested to see a copy of the Statement of Objections. And I was told, that's confidential. And I said, oh, well, you know, it's kind of normal in Europe to tell the accused what he's accused of. Confidential. Well, it says in the, you know, that thing, the Strasbourg Human Rights Convention, it says, you know, there's stuff about this and Article 6 and all that. And the colonel, who was the brigadier, who in his former profession, who was in charge of the investigation, said, Professor, where were you? Where was human rights when my people were being slaughtered? Yes, well, that's indeed a point of view. Let's go on and talk about substance. So those were the early days of a competition authority. And people with as many grey or silver hairs as John Temple Lang and myself can remember the early days in Brussels. And at the very beginning, as you know, Regulation 17 of 1962 was the basic architecture for the running of the competition rules in the European community. And Regulation 17 was, of course, taken over in lots of big ways in 2004, but the provisions on, the basic provisions about the structure of how inquiries were organized, the new regulation isn't so different. It is in certain ways, of course, to Regulation 17. And back in the 60s, which I don't remember, and the 70s, which I do remember.
No one remembers the 60s.
That's right. Just as well. During those exploratory days, there was, it was natural and understandable, certainly at the beginning, that competition should be regarded as something a bit like a tax administration. Now, in other words, an inquiry. Did that trip to Vienna really fall within your professional expenses, or was it really a holiday thing? And then there's hearings, and if you are really insisting, you can be heard by an appellate panel, but it's always inside the same institution. What you're doing is trying to persuade the institution that it got it wrong. Now, that was the point of view, very understandably, at the beginning of the European Commission. And it was, of course, a view which practitioners disagreed with. And for as long ago as I can remember, practitioners were saying, well, no, this isn't an appropriate approach. This should really be, it's like a trial. You're accusing us of doing something wrong, an economic crime. That's bad stuff. And so we're entitled to protection, sort of as if it was a criminal matter. Now, those arguments popped up in different ways consistently or frequently during the 70s, 80s, and indeed 90s, and they were consistently rejected by the European courts. I'm speaking in very broad general terms. But at the same time, the European institutions realized that there was a tension between a private administrative style of approaching economic misdeeds or excesses, or insert your noun, and due process. And so in the celebrated IBM case, that was the first time that there was a realization on the part of the hierarchy of the competition authorities that relations between the two sides had become polarized and hostile. And so in order to keep the hearing tranquil, because it was going to be very big and very important, very sensitive, a retired director from Ireland was brought to supervise the proceedings. He wasn't called, I think, the hearing officer, but he was Conor Maguire, I think it was, had the job of supervising fair play in the hearing, so that he got 20 minutes, they got 40 minutes, he got 20 minutes, and the hearing proceeded in a serene manner. On another occasion, the commissioner said indiscreetly to a group of press people before the hearing way before the case was over, that this was the worst instance he'd seen of anti-competitive behavior, or something like that. And that presented some embarrassments, and in response to the criticism, which was settled in that particular case, the institutions adopted more prudent, protected practices for the role of the commissioner. And so today, even though there's no, at least I speak subject to correction, even though there's no regulation that says other commissioners won't receive visits from companies which are threatened with a negative decision, the other commissioners are, I think, much more conservative and cautious today than they were in what we may call the good old days. And so the unique procedures of the European institutions have adapted themselves in light of internal reflection, peer pressure, newspaper articles, press reports, appeals, even if unsuccessful. So the practices which Christa Kaiser has been describing are much more, very considerably different to what they were when John Temple Lang and I were young in Brussels in the 70s. That's partly because of a recognition that modern standards of due process have evolved. It's partly because of cases from the Human Rights Court which have confirmed the criminal, quasi-criminal nature of competition cases, even though, of course, the fine is an administrative fine. There's aspects to the procedure which clearly are accusatory, and there's a bunch of Human Rights Court cases, Drusilla, Menarini, you know them, which appear to support, and I'm for once being cautious in what I say, appear to support the proposition that in a competition case, the accused company is entitled to certain protections, and on appeal is entitled to a thorough review on fact and law. Now, since we're talking about judicial review and disclosure of evidence, I'll note a couple of things. One is that the court, from the earliest days, there's a case, I think, in the 60s, but it may be in the 70s, where a notification was made, I think, by the famous practitioner Michel Walbrook, and a notification was a request for the Commission's blessing. The blessing was given subject to conditions which had not been put to the party, and the court annulled on that basis. So the court has not been inactive in individual matters, specific matters, where it seemed that the processes that were followed by the institutions weren't appropriate. On the other hand, as to the big picture, the court has, the courts across the road, I mean, as to the big picture, the court from time to time has said two contrasting things. One is that in complex economic matters, there will be, and these are my words, not the court's precise words, the Commission services are entitled to deference, and one can absolutely understand in complex economic matters, in complex matters which are essentially regulatory, it's perfectly understandable that a court will be very reluctant to interfere with the decisions of the public authority. So if the question is whether the disabled child is so disabled as to be entitled to a free bus pass or special learning school access, the court, any court, is going to hesitate to second guess the public authority. On the other hand, when it is a question like an accusation based on whether John Smith was there on the 13th of January at the meeting in the Sofitel in Frankfurt, that isn't quite the same category of administrative decision. So in a succession of cases, which again are known to you, I happen to think of Halcor, the Court of Justice and the Court of the General Court have elaborated definitions which require us to be, I think, more exigent than we were in the past. So there's the overall environment. A few signposts along the way. As I said, in the very early days, we were all practitioners, academics, and officials in the same, swimming in the same pool. Each decision was a surprise. There were very few decisions, maybe less than 10 applications of what's now 101 and 102 in a year. And everyone was looked at with through a magnifying glass because the Commission was extremely cautious. And each decision was regulatory flagship. And then there came a period of evolution, more confidence, more cases, not necessarily more cases, newer theories, and a realization that the competition rules were contributing successfully to the integration of the European adventure. And then the third phase, in say from 2000 onward, with the rewriting of the basic structures of the competition rules and the sharing with the public authorities. Now, during that time, we can see an immense evolution in the extent of access to the file and the procedural rights of individuals. The creation of the hearing officer, a distinguished former official and current official, but the role of the hearing officer and how far the hearing officer could go. It remains fundamentally that the hearing officer is there not to decide the case, but to ensure fair play during the proceedings. Now, as cases get more complex, as the big dominance cases get bigger and huger, the challenge of access to the file and the challenge of adequate judicial review, those get bigger and bigger. And we work in the single working language of French, and our competence is review of legality, comma, plus the obligations of a rigorous review prescribed by Menarini, etc. Menarini and Halcor and others. So on the one hand, we have to look at whether the institution had a legal basis for doing what it did, but it will be extraordinarily rare that the institution doesn't have a legal basis for what it did. And on the other hand, we have to examine fundamental notions of accuracy or solidity, validity in fact and law. So that task, as I stated in abstract manner, becomes even more challenging, more substantial, more, there are people writing this down, so I won't say alarming, but substantial. If one is faced with hundreds of pages of decision, 700, 900 paragraphs, 200 pages of application, and a file that's maybe, I mean, that big, several kilos. Now, doing judicial review of the adequacy of the decision of the institution, even if the institution gives tremendous, completely uncontroversial access to its own file, it's a very great task. The task is made more difficult when claims of confidentiality are extravagantly made. And I remember as a young lawyer, it was fun to black stuff out, and that was sort of encouraged. It was part of the game. And we have encountered the situation where sometimes parties have been so enthusiastic with the felt tip that there's nothing much to be gained from looking at the underlying documents. And we have, I record it publicly, successfully invited parties at an informal meeting, so-called, to be more reasonable and not to leave it to us to decide hundreds and hundreds of questions of contested confidentiality. Last point that I'll make is that the topic which we heard about very little may come back, and that is the caseload of the European institutions of the Commission has greatly evolved following the evolution of the leniency process. A leniency process whereby the Commission says, we think you're guilty, please are you interested in doing a transaction which will accelerate the case and then possibly bring a lower fine. the leniency documents which are delivered or spoken to the Commission are obviously very sensitive from the point of view of follow-on litigation. And there have been a number of cases where access to such documents have been requested in a bunch of courts. Our court gave a judgment in Fleiderer. There's a number of others, and there have been a number of others in other courts around the world where access to these self-incriminating documents have been sought by parties who wish to engage in follow-on litigation. That, I predict, is going to be an area where there will be continued controversies, and where the Commission's position thus far has been very clear and very consistent, but I expect there will be variants on that which may come up from time to time. So, history, gradual evolution, practical problems addressed to resolve them, addressed by this court from time to time. Big change in the volume, complexity, and massiveness of documentation in big files, and leniency documents, probably a continuing source of controversy. And there I'll stop.
Thank you very much, Judge Forrester, for your account of the history and where we're actually coming from and where we are today. We will now add another dimension or an aspect to this discussion from a different jurisdiction from the US, and we are looking forward to your words, Judge Ginsburg.
Thank you. Well, I want to begin by congratulating the authors of the report. If you haven't seen the report, I commend it to you. It's a draft final report, oxymoron that we can all live with. Professors Yu and Fetzer and Wang have done an excellent job of assembling a picture of where we are in these three major jurisdictions at a time in which it's quite likely to be influential. There is a growing, and I think not yet peaked concern around the world with due process in competition proceedings. And those of us who live in the competition bubble can see that happening. Whether it's generalized beyond competition, I don't know, but it certainly is growing in our circles. And that's reflected in the references in the report at each junction to the international norms as represented by reports, recommendations, and so on, coming from the International Competition Network, the OECD, the American Bar Association, the ICC. There are probably others out there as well, converging pretty closely on basic principles of due process, and to some degree on details as well. We're all swimming upstream from our starting point, which was memorialized in the Alice in Wonderland, in which the Red Queen says, off with our heads, judgment first, trial later." Probably the most dramatic and early example of confirmation bias. Imagine coming to a different conclusion after the execution. It would be unlikely. As further evidence of this, I'll just say that several references have been made to Menarini from the ECHR, and was acknowledged in Schindler and other cases here in the ECJ. But it has its mate in Regina versus Wigglesworth, a Canadian decision of the Supreme Court, invoking Section 11 of the Charter and saying basically that the stakes in competition proceedings are significant, and therefore the norms applicable to criminal proceedings are equally applicable to Canadian competition proceedings. And it's on that very point that I want to dwell for a moment. That is to say that the stakes are increasingly over the last 2 decades ever larger. In Europe, of course, they're expressed primarily, well, exclusively in terms of corporate fines. In the U.S. and now in the U.S. often in criminal convictions as well for individuals. And there are now 30 jurisdictions that authorize criminal proceedings. There are very few such proceedings. Most of those statutory reforms are new. There are, I think, 3 cases have been brought in the UK. Marine Hose successfully prosecuted, a second case in which it was terminated because of some mishandling of the evidence, and I think the 3rd is pending. So we can expect more and more criminal enforcement around the world, and even greater attention to a need for observing due process norms, and I think norms that are essentially comparable to what we would expect in criminal proceedings in the most advanced or experienced jurisdictions. Now, what do we mean? Well, of course, by due process, it's inherently a broad notion that gets particularized through case developments. I'll share with you a passage from a 1907 case in the U.S. Supreme Court. Quote, "A precise definition of due process has never been attempted. It does not always mean proceedings in courts. Its fundamental requirement is an opportunity for a hearing and defense, but no fixed procedure is demanded. The process or proceedings may be adapted to the nature of the case," which I think is an extremely important starting point. In 1970, the U.S. Supreme Court, in a case involving termination of welfare benefits without pre-hearing. So there was a termination first, hearing later, off with their heads, trial later. The court said, Goldberg against Kelly, the court said the extent to which procedural due process must be afforded the recipient is influenced by the extent to which he may be condemned to suffer grievous loss. So again, an equation between the stakes at risk and the degree of process indicated. And so now we have cases in which there are fines in the auto parts cartel in the U.S. of $1.6 billion in criminal fines, indistinguishable from a civil judgment, really. 500 million and up in the AU Optronics cases. And here in Europe, judgments of a similar range, hundreds of millions, almost a billion euro in a single judgment. So there's no real doubt that the stakes have become not just episodically, but routinely extremely important. That's not to mention the reputational consequences for anyone, either individual or company, that is found to have engaged in a willful infringement. Now, I'm going to turn to the report itself to identify a few points that I think deserve some comment or elaboration. Much of our discussion in the panel has been about the open file policy, which is extremely important. And of course, the devils are in the detail of how it's administered, as Judge Forrester has pointed out. But it can't be gainsaid that it is extremely important. It fully articulates and as a corollary the idea that one must know what the charges are against one, and that those charges are informed by the things in the file. And without that access, the procedure is bound to be, or inclined to be, defective. In the U.S., the Antitrust Division maintains an open file policy, but curiously, U.S. attorneys vary. There are 91 U.S. attorneys, one for each judicial district in the country. So at least one in each state, sometimes as many as 3. And some have an open file policy and some do not. And in Virginia, where I live, it depends on the individual prosecutor. The U.S. attorney leaves it up to the individual who's in charge of the case. It's a very curious arrangement, and one that I hope we can improve on. The direction of improvement is easy to discern. Now, on the disclosure in particular of exculpatory information, this is I think, a particularly, an area particularly prone to omissions, let's say. It virtually invites confirmation bias. The report recounts that while Chinese officials emphasize their internal consideration of exculpatory evidence, they have no legal obligation to disclose it to the parties or the public. Chinese officials also emphasize that their internal reports and evidence will be available to courts under judicial review. However, as discussed later, judicial review and enforcement decisions has thus far been sparse. So here you have the prosecutor being asked to determine what is exculpatory and therefore must be turned over. And whether something is exculpatory is not necessarily self-evident, or let me put it another way, not necessarily undeniably obvious, and may require some interpretation, and a sympathetic interpretation would seem to be indicated, but unlikely, frankly. In the US, the Supreme Court, in a case called Brady, has made it a constitutional obligation to turn over exculpatory evidence in a criminal proceeding. 20% of all appeals in criminal cases involve a claim of a Brady violation, for what that's worth. I don't know how many times that's actually valid. It is probably the single most frequent ground for an appeal. And I think that's not necessarily a reflection of bad faith on the part of prosecutors, but rather of the interpretive nuances as necessary to make those judgments, and how perspectives on what is exculpatory differ. Indeed, prosecutors may not be aware of the facts that would make something exculpatory. The respondent may be, surely is in the best position to identify and latch onto something that holds out promise of exculpation. We had this recent small aspect of the Intel decision here in the ECJ, in which the court faulted the commission for failing to make a verbatim record of an interview, which the rules actually seem to have required, recording all interviews in full. It was harmless error in that particular case, because there was so little prospect that, so the court thought, that a full text would have been exculpatory, although it seems impossible, frankly, for anyone to have known, since there was no record of the interview. And the court seemingly placed the burden on the company and said they failed to show that it would have been exculpatory. Well, that's not too surprising. On the other hand, I think it's an extremely important decision, because I would anticipate that the commission will not henceforth take a chance on the same error being consequential. Why should it? It's no big problem to record the interview. It will be useful in some cases, and there was the message sent should have been fully adequate. I think the court did all that was necessary, not necessarily for the respondent in that particular case, but for the procedure going forward. Turning to the disclosure of the legal, economic, and factual bases underlying the agency's investigation. Again, I'll start with a brief quotation from the report on China. China's law does not specify that agencies must disclose the economic theories underlying their investigation. However, the parties are permitted to defend their case, and the agency is obligated to re-examine any facts, evidence, and theories presented by the parties, and, if true, accept them. Well, it's not quite execution first, trial later, but it is veering in that direction, let us say. We have our theory We'll let you know what it is when we see if you have any exculpatory evidence that requires us to rethink our case. So this is a major lacuna, really, in a procedure. I don't mean to single out China. It's true to the degree that any jurisdiction in any particular case fails to share in a timely manner with the respondent what the agency's theory of harm is. And I think worst, it is an invitation to not develop a theory of harm. And we've seen that happen in some cases where the theory of harm is either indiscernible on judicial review or seems to be a post hoc justification that is cobbled together for the purpose of defending the judgment in court. And the importance of insisting on there being a theory, an economic theory of harm that has been shared with the respondent in a timely fashion could not be more important. It determines the direction in which internal investigations will go, the direction in which evidence will be assembled, both for exculpation and otherwise on both sides, and it's really quite essential. So that it ensures that there will be a theory of harm, as well as informing the proceedings at an early stage, as Mr. De Keyser reminded us. A passage from the U.S. here in the report. In the U.S., the defending party in a judicial enforcement action enjoys the full benefits associated with jury trials. The benefits associated with jury trials sounds like a full realization of the ideal, but even that is in tension with the disclosure that I think everyone would agree is appropriate and early. I convened a meeting in 2014 at the outset of the Global Antitrust Institute, which I'd created in 2014 at George Mason University. We had 14 agencies in attendance, and the representative from the Federal Trade Commission, who was a litigator, said that he wanted to be able at trial to confront the executive of a respondent company with a heretofore unseen, unremembered email and say, well, what do you think of this, Mr. So-and-so? Let me read this to you, what you wrote on January 14th of last year. And the surprise element was exactly what was wanted for litigation. And that's got to be true of litigators in any place and at any time. But it's in fundamental tension with the notion of a full disclosure in a timely fashion. So the resistance, or the, let's say, disinclination of prosecutors to show their hand entirely cannot be discounted when we think about how disclosure is going to work. Finally, and this is under the heading of international norms at the close of this section on disclosure in the report. The OECD Policy Roundtable recommends that, quote, defendants should have the right to a hearing before the decision maker or fully empowered agents, in addition to the opportunity to respond in writing. And the key in this, I think, is the phrase, or fully empowered agents. The opportunity to present one's case to the decision maker, it seems to me, is an indispensable part of due process, as our Supreme Court has once had occasion to say. But it is not the norm in many well-respected agencies, including the U.S. Federal Trade Commission, and as far as I can tell, the European courts as well. Let me put it this way. Who is the final decision maker in a case coming up through DG Comp? Is it the Director General? Is it the Commissioner? Or is it the full commission of 28? Well, the last seems most improbable in most cases. I think Google is the only recent case in which the full commission seemed to have reportedly had some input. But who knows? Is it the commissioner? Is it the director general? Is it someone below them? They do not attend the hearings. And they are informed by fully authorized agents acting in good faith to relate to them what transpired at the hearing. It could be worse. At the U.S. Federal Trade Commission, an administrative law judge, who is not one of the 5 commissioners, the administrative law judge conducts the hearing. The transcript is provided to the commissioners. And by statute, the commissioners have the authority to overrule the hearing officer on matters of fact and credibility, although they weren't in attendance at the hearing. Now, these deviations from the final decision maker to some duly authorized agent strike me as potentially very significant in individual cases and a major departure from what should be expected of due process in proceedings around the world, and probably not just antitrust proceedings. Thank you.
So thank you very much for these remarks. Thank you very much also for being specific to the report that tells us that there's improvement that can be done. I should explicitly also say this about the Chinese part, where Professor Yu and I and Professor Wang had been working together, and we understand that now, due to the merger of 3 independent agencies in China for the enforcement of antitrust, there are also new procedural guidelines which we will have to introduce to this report to be really current and recent. I'm glad that there's some disagreement if everything is perfect and could not be improved, because this gives the opportunity to questions, and I would give this opportunity first to the floor, so to the audience. We have some time left because due to a typo, this panel was shortened to 1 hour, whereas the others have 1 hour 15 minutes, and that seems to be discrimination that I will not allow for, and there's no justification for this discrimination. So are there any questions? So we have a mic because we want to record it.
Reading the report very quickly, I find it excellent, but I find that it fails to consider one aspect, which is the difference between the adversarial procedure and the inquisitorial procedure. And this is relevant, I think, because the key difference, in my mind, is that in the adversarial procedure, you have a right to cross-examine. And that is unusual and I think almost unknown in the other procedures. Now, it's not enough to get all the documents that are on the file of the authority concerned if you haven't got an opportunity to challenge whatever is in them or whatever conclusion can be drawn from them. There is a risk that if you merely have a right to produce contrary evidence, you will get 2 experts or 2 bodies of evidence contradicting one another, and it won't be possible satisfactorily to resolve the issue. I think this is something that needs to be considered.
I agree. We have a very short sentence in the report saying that this is a major difference. We were not sure how important it actually is, but that's one thing. And thank you for this comment, and we will for sure consider it. There was another question here. And if you could briefly introduce.
I'm Thomas Wesley from Freshfields in Brussels. We heard a lot about the procedural safeguards, and Chris, in particular, when you list them, it sounds very impressive. You have the hearing officer, the internal scrutiny unit, the CET, the advisory committee. But as a practitioner, you are not so impressed when you go through it in practice, case after case. We had a lot of hope in the CET. In the meantime, my impression is that the CET is basically being used, so the chief economist team, to support the case team as much as possible. Where the case team struggles to complete its theory of harm, the CET is rather being asked to plug the gaps than to question the theories of harms, and I admit that's the outside view. the internal scrutiny unit, from the outside, you don't see any effect. It would be interesting if you could comment a bit on it, on the practical effect. But in particular, the hearing, I've gone in quite a number of hearings, and at the end of the hearing, we thought we had presented in quite a powerful way the mistakes we thought the Commission had made. And of course, presenting all of that doesn't mean you have a right that the decision is being changed or the theory of harm is being revoked. But in the meantime, we are in a situation where more and more parties don't use the hearing because there is a growing impression that the hearings are useless, actually. And what does this tell us about this procedural safeguard? If the parties themselves for whom this has been put in place think it's no worthwhile to go into hearings, and I've been reading, I've not counted myself, that at least in merger cases, in half of the cases, the parties do not prevail themselves of this procedural safeguard, which raises questions about the effectiveness of hearings. Thank you very much.
So I guess this goes to Christa Kaiser.
So you mentioned the chief economist. So the chief economist is there. So the chief economist, in fact, has, or the team of the chief economist has indeed, can be asked to help out on, for instance, building an econometric model. But the chief economist himself, in fact, is totally independent and makes up having his views on the case, and may, independently from what, for instance, members of the team has done when they were building on this economic model, come to different conclusions. So maybe you have the perception that he may be biased, but that is certainly not the case. So he is indeed part of the decision-making process. He gives his opinion directly to the commissioner on the economic strength of the case, and therefore he's an important part of this internal checks and balances, because he is the one who then gives really an opinion on the economics. Would that mean that parts of the, so that members of his team would be precluded to help out? I would think no, because at the end of the day, that's then a different function he has. So they do then the support function, but the scrutiny function is with the chief economist himself. And so therefore he has, within the team you may have a little bit that double role, but the chief economist himself really has this scrutiny function and gives his opinion. As to the coordination units, you may not see that because, of course, it's not the objective that, for instance, you would get in touch with members of the coordination units to then redo the case. It would not be very efficient, it would not be very effective, but I can assure you that the coordination units play their role at different stages in the proceedings. From the very beginning, for instance, when a case, when it is decided to prioritize a case or not, and in the different stages of the proceedings, the coordination unit comes in. When there is a draft statement of objections, it goes, for instance, to the coordination unit, which also looks at it and gives an opinion on the soundness or not of the case. So when it comes to the hearing, so the role of the hearing, it's certainly not a contradictory procedure between DG Comp and the parties. That's maybe a misunderstanding with the hearing officer as a judge, but it gives the opportunity to the parties to make known their criticism, their views to the Commission, either by producing documents and then raise awareness with all actors involved at the hearing or presenting witnesses. The fact that the parties do not use that opportunity, of course, that I leave to you, because that's, at the end of the day, your advice to the parties, but I would advise them to use it, because the hearings are an opportunity to make known your views. As you know very well, at the hearing you do not only have the case team which is there, but you have also other actors which are involved then in this internal checks and balances. The chief economist is present, the members of the peer review panel are present, the legal service is present, So the hearing officer is there, and all these actors, so you have the members of the advisory committee which are there, also other services of the commission, and all these actors hear then very well your arguments and then take it up when they then give advice. And at the end of the day, when a draft decision goes to the college, you have the advice of the legal service, you have the report of the hearing officer, you have the advisory committee. So all these, let's say, mechanisms are into play in order to make sure that when the college decides, it have a complete overview. And so the hearing in that respect is an excellent opportunity to make known your views to all these people.
There's an immediate remark by Judge Ginsburg, and then I have a
Well,
question in the back.
Just your point about the economists supporting the case and having the role of supporting the case. I would just point out that in the U.S. for a long time, until sometime in the 1980s, I guess, the economists and the lawyers were loggerheads all the time. It was true then, it's true now, I think it's true in the EU as well. There are many cases that could be brought and won that would be, that should not be brought from an economic point of view. So the lawyers were known as case killers, the economists. The lawyers would develop this case, they knew they could win the case, and the economists are saying, well, it would be wrong, let's not do it. In 1985, I made the chief economist equal to the chief of the legal side, and I think it would be extremely rare for the U.S. agency, at least the antitrust division, I think both agencies, be extremely rare for them to bring a case that the economist had not supported, had recommended against, and therefore it's of no significance that the economists are supporting the case if it goes through trial or through judicial review.
Christoph Swaak from Stibbe. I live in the antitrust bubble and already for a long time, and I also feel sometimes that it's really unfortunate in the European system that there's no cross-examination. But given that's a fact, you wonder once in a while, litigating in Luxembourg, why the court does not more often use the possibility it has to hear the witnesses, or to, if they look at files and documents that can be interpreted in different ways, and the European Commission gives an interpretation A, and the party gives an interpretation B, and the author, for instance, of the document is still available. Is it correct that I have the impression that the court is very reluctant to take a step forward and basically say, why don't we invite the author to come? Can't the court be a little bit more active in clarifying certain issues that are important in the file? And that doesn't mean that we need to go as far as having a cross-examination system.
I guess that's going to Judge Meisner.
Right, I guess that's directed to me. We sit in chambers of 5 judges, sometimes in a formation of 3, and in big cases it's commonly 5. Each chamber, I won't say makes its own rules, but it has its own habits and preferences. The rules of the court certainly permit inquiry into the details of the evidence, and we have a case next week or the week after, which presents exactly that question. One party says so much, the other party says something different, and we've invited counsel to come, and there will be vigorous discussion as to what the documents mean. It is true, I think, that practice varies. It's also true that in in my previous life, I did see occasion where professors of medicine, it was about the safety or not safety of a feed additive. And there were eminent scientists of different points of view who gave their views. And one of the challenges for the court is to distinguish between the substance of what the expert says and the skill and articulateness with which the expert speaks. And that's familiar to any practicing lawyer. But implicit in your question is the proposition that the court doesn't make those inquiries. I can say that in my experience, short nonetheless, the court does make those inquiries. And I would give you as advice that if you think it would be helpful to hear something, or if you think a particular inquiry would be useful, then you should certainly propose that.
There's a question here in the middle, and another one here.
Thanks. My name's James Aiken. I'm also from Freshfields in London and Brussels. Just as a supplementary point to the point we've just been discussing, I think it is important to be clear about what we're talking about when we speak about access to the file, because the file will consist of a mixture of contemporaneously produced documents and these days increasing amounts of responses from parties and third parties to requests for information, which will be strategically prepared both by the parties and third parties, many of whom will be complainants. And that evidence, for want of a better word, is increasingly relied on, particularly in Article 102 and merger control cases, which are an increasing amount, as we've been talking about, of the Commission's workload these days. And from the point of view of a party, both at the Commission level and, I hear what Judge Forrester says, but also I think at the judicial level, the feeling that one has is that it's very difficult to test the competing statements of opinion, essentially, that are often made in replies to requests for information, because you'll have a he said, she said situation often, and there's no ability to really, put to the other side, haven't you only given a partial view of the situation, and really kind of, did you prepare this after the event? Did you prepare this in consultation with your lawyers? The kind of thing that you would expect to do in other legal contexts. So I think that's an important point about what the file, when we talk about access to the file, what does the file actually consist of, and what is the evidence that's relied on? Because if you look at many decisions these days, the footnotes that are relating to the evidence are actually relating to responses to requests for information, which are essentially opinion of parties and third parties. And one smaller point to pick up on a point that was made in relation to the timing of access to the file, and I think it was generally thought that that was a suitable point in the case at the time of the SO. I think again in cases where 102 and merger control are involved, the SO has been prepared over some time by the time it's sent out, and particularly in the merger control context, it's often at quite a late stage, and the SO's really in the nature, it sounds like, of the report that's been prepared. It's really a draft final report, final decision, which is being checked. There are very few examples in practice of a case being completely dropped or the whole complexion of the case being altered entirely once the SO has gone out of the house. And I do think that there could be benefits for both sides, actually, if there could be earlier disclosure of key information in documents at an earlier stage in the procedure, particularly in merger control, but in antitrust as well.
Any comments? So, there was another question here.
Maybe on the timing. So in principle, and in particular in mergers, of course, because of the delays, it's maybe a different ballgame. But in particular, also in antitrust, we do consider that the moment of the SO is the appropriate moment to give full access to the file, because it is at that moment that it becomes really clear on what essential evidence the Commissioner relies, what are the theories of harm, and it would probably also not be very efficient and effective to burden a lot of other third parties and so on at a moment where it does not really matter yet. Having said that, as you know, we have with our best practices, and we are convinced that a good interaction between the Commission and the parties at an earlier stage can be useful for both sides in order to have a better understanding of complex issues at an earlier stage. It could be useful for us, it could be useful for the parties. And that's why in the best practices we have, for instance, introduced this provision that says that we will give already at an earlier stage access to key submissions, including also key economic submissions from third parties, from complainants. We also have state of play meetings, which are before SO. So at the state of play meeting, you can already go, you become aware of the parties' arguments at a relatively early stage, which can help to move forward also only with well-founded cases. So we have the state of play meetings, we had the earlier disclosure of key submissions, also submissions of economic evidence. All that helps, and so you will also know that in a case, it's not that you have radio silence until SO. We enter into contact with the parties because it's also in our interest. But to go then to the next step and to say you should have continuous access to file, there you go into the issue of finding the right balance between and also to make sure that you have effective enforcement, and there we think that this is the good moment in time to give full access to the file.
So we have room for, I think.
Can I get Judge Ginsburg's thoughts? Because you've served both as an enforcement official and a judge. I would love to draw your perspective on the timing of access to the file and the trade-off between effective enforcement and fairness.
Christopher, I actually am at somewhat of a disadvantage because as head of the antitrust division, I had not come up through the ranks, and so the process was not so self-evident or revealed by the time it got to me. And it's probably changed a good deal since then. That was a long time ago. But I will say that the one flourish in the way in which the two U.S. agencies operate is that before a final decision on bringing a case has been made, the parties are invited to meet with the head of the agency or with the commissioners of the FTC individually, not to go together, and to make their case one last time to the actual decision maker on whether to bring the case. And that's, I think, an important feature of the system, because the final, that perspective may be quite different from that of the staff.
So a lot of food for thought, food for our stomach is coming. So two last questions, short questions with asking for short answers.
Thank you. My name is Cléon Gély from Norton Fulbright in London. Actually, I wanted to continue the discussion on leniency statements used as evidence. So we talked about the way a party can access them, but what's interesting to me is the weight they have when they are built into a decision. I'm concerned that in the context of a practice where you have more and more settlements, so shorter decisions, you also have a lot of reliance on leniency statements. And by nature, leniency statements are a bit self-serving. Companies are trying to get a reduction of their fine. If they are not the first in line and they come second or third, or they suspect that they come second or third, they will try to be a bit creative into finding an infringement. And so what we have seen in the EU, or what can be suspected, is that there is an intention to kind of, or there is a consequence indirectly to expand the buy-object box by coming in with a very novel theory of harm and saying, well, this is a counter infringement, so I should get a reduction, and the Commission should take this on. Obviously, this is a bit of a concern, because if you are a company that was having a minor involvement in the infringement, maybe you have no material to apply for leniency. Or even worse, if you are an intermediary parent company and you were never directly involved in the infringement, you have no material to apply for leniency. So you are a bit at a disadvantage, and I feel that maybe there is some safeguards around the use of leniency evidence that should be put in place. I would like to have your views on that.
I'm not going to give you a helpful answer. I will give you a truthful answer. The status of leniency confessions, shall we call them, has been the subject of differing assessments by the courts, and the anxieties that you express are not new. The issue of how to balance the efficiency of the inquiry and the fairness to the persons inculpated by the leniency statements, those are real questions which are being litigated currently. And you should read the judgments and write articles about them when they appear.
So, one last question from the back.
Yeah, I have a question.
Could you take the mic and introduce
Thank you.
yourself briefly?
Thank you very much. Mattia Melloni, I'm a member of the Luxembourg Competition Authority. So my concern is about access to the file that varies from countries to countries. Within the European Union, you have access to the file that is extremely different from one country to another one. Now, as a concern that I have, namely, I just wonder whether it wouldn't be nice to have an harmonized system within the European Union with a minimum set of rules that guarantee access to the file throughout all NCAs. Because what we see nowadays sometimes is that in some member states, for instance, access to the files that the national competition authority gives to the company can be put in danger before a national judge. So this is something that should ring a bell, within the European Union, because at the end of the day, we treat differently companies when it comes to access to the files for antitrust cases. So I would like to hear from Judge Forster, for instance, his experience about cases that he defended before national courts vis-a-vis European courts, for instance. Thank you.
This is really a question for my neighbour on the left. But it is true, and I have written about it, that there are differences in the procedures all across Europe. That's right. My adventure in the face of the Eastern European Competition Agency was at one extreme, and discussion before the CMA or the Conseil de la Concurrence would be very different. Yes, procedures are different. Yes, procedures change from time to time. I think several people have noted that there is a big difference between a prosecutorial regime, an adversarial regime, and an administrative one. And it has been suggested in different law review articles that the hearing officer, speaking now about not the discrepancies, but rather the lead agency, which obviously is the European Commission, whether its processes might be made more, might be changed successfully or advantageously by giving more power to the hearing officer. At the moment, people who approach the client, the company who's going to its first hearing, assumes that there's going to be a wise person sitting in the chair, and there will be one side and the other side. There is a wise person sitting in the chair, but that wise person doesn't, as in a normal, for example, a criminal hearing, which is something different, say, what does the policeman say? And what's your answer? But surely, that's to say it has been suggested that and I am not suggesting it, that the process could benefit from according greater powers of fact determination, maybe, when there's an argument as to whether he was or wasn't at the meeting on the 13th of January. That's an interesting question, and that would be a possible alteration in the practice, which has been written about, and thus far, for good reason, the institution has decided not to embark on that route. But there are many differences, and if you speak to practitioners who've been involved from Greece to Ireland and Finland to Portugal, they'll tell you what those differences are. And one of the initiatives currently brewing in the United States, one of the suggestions of which you will have heard is that there should be the adoption of, what should I call it, common standards or aspirations of procedural normality in competition cases. And that's another interesting question which will continue to cook, I guess.
It's called the Multilateral Framework on Procedures in Competition Law Investigation and Enforcement. And that's aptly named because it is only a framework on procedures. And each of these specific procedures is subject to, of course, variations in local law, the degree to which practicality admits they're being followed in a particular proceeding. They're really not very constraining, and one would have thought that that jurisdictions would be lining up to agree.
Can I just two short comments on that? This is the so-called MFP, and you know that in terms of the content, also we don't have any problem because these are key principles which are very, very similar to the guiding principles of the ICN with the OECD guiding principles. So as to the substance, we don't have any problem. We just question whether it is useful to add still another let's say, layer, because already authorities have to invest a lot, for instance, in contributing to the ICN, to the OECD, and we think that this initiative, which is in terms of substance, so no problem whatsoever, but we think that it would be better if it would be brought under the umbrella of the ICN, but very short on that. In the interest, because we also had a lot of food for thought, but there's a lot of food waiting for us. So, of course, there are different regimes which may require different solutions. Having said that, the ECN Plus directive, which will soon be adopted, will allow indeed, and because there comes now a period for implementation, and that I'm sure will lead to further convergence on all these matters as well.
If I may just say that without knowing whether it'd be better done through the ICN or not, wherever it's proposed, I think if the European Commission were to join with the United States and just a couple of other jurisdictions, it would have an enormous benefit in terms of the many other jurisdictions that are not currently so well aligned with the procedures.
So I hate to interrupt this discussion, and I would like to continue it, but I think I have to interrupt this discussion. And I would like to thank you, three fantastic panelists, and please join me in thanking three fantastic panelists. So I don't want to rush you too much in terms of lunch, but I suggest that we meet here at 1:20 plus 2 minutes to come back here for the next panel.
Chris.